Mr. President of the ICJ, and members of the court. My name is Pisonanta Krisetia, and it is an honor for me to appear before you on behalf of the Republic of South Africa. This case concerns the application of the Convention on the Prevention and Punishment of the Crime of Genocide, a treaty that imposes obligations not only to punish genocide once committed, but to prevent it before irreparable harm occurs. South Africa appears before the court not as an injured state, but as a state party acting in fulfillment of obligations owed to all under the Convention. Mr. President, there is no dispute that both South Africa and Israel are parties to the Genocide Convention, and neither has entered a reservation to Article 9. Accordingly, the court has jurisdictions over disputes concerning the interpretation, application, and fulfillment of the Convention. As this court confirmed in the Gambia versus Myanmar case, the obligations under the Genocide Convention are erga omnes partes. Any state party may invoke responsibility where there is a serious risk that the Convention is being violated. South Africa's own history has demonstrated the grave consequences of international inaction in the face of systematic dehumanization and destruction of a people. That experience does not confer moral authority. It reinforces the legal obligation under Article 1 to act where the risk of genocide becomes apparent. Members of the court, Article 2 of the Genocide Convention defines genocide as the commission of specified acts against a protected group, committed with the specific intent to destroy that group in whole or in part. This court has consistently held that genocidal intent may be inferred from a pattern of conduct, the scale of violence, the systematic nature of acts, and the foreseeable consequences of those acts, particularly where direct evidence of intent is unlikely to exist. The protected group in this case is Palestinians in Gaza, who constitute a distinct national, racial, and ethnic group. Palestinians in Gaza form a substantial part of the Palestinian people. As the court held in Bosnia versus Serbia, the destruction of a geographically limited part of a protected group may fall within Article 2, where that part is significant. Mr. President, South Africa submits that multiple prohibited acts are plausibly established. First, killing members of the group. Since October 2023, tens of thousands of Palestinians in Gaza have been killed, including a strikingly high proportion of children. These deaths result from sustained military operations conducted in one of the most densely populated civilian areas in the world. Second, causing serious bodily and mental harm. Tens of thousands more have suffered severe physical injuries, amputations, and lasting disabilities. The constant bombardment, mass displacement, and destruction of family units have inflicted profound psychological trauma, particularly upon children. This court has recognized that such harm falls within Article 2b. Members of the court, the aspects of this is central, which is the inflicting conditions of life calculated to bring about physical destruction. Gaza has been subjected to conditions of life incompatible with the survival of its population. There has been severe restrictions on food, water, fuel, electricity, and medical supplies. The destruction or incapacitation of hospitals and health infrastructure, the displacement of vast majority of the population, and the emergence of famine conditions, repeatedly warned of by United Nations bodies. As this court recognized in Bosnia versus Serbia, genocide may occur through deliberate deprivation, where a population is slowly destroyed by the denial of the means of survival. Mr. President, genocidal intent is rarely explicit. The Convention would be deprived of its preventive function if intent could only be established through express declarations. This court has held that intent may be inferred from conduct, including the scale and repetition of acts, their foreseeable and actual consequences, and the statements of state officials. In this case, senior Israeli officials have repeatedly employed dehumanizing rhetoric directed at Palestinians at Gaza. Such statements have not been meaningfully denied or sanctioned. When such rhetoric is accompanied by conduct that predictably results in the destruction of a civilian population, a reasonable inference of intent arises. At the very least, the fact established a serious risk of genocide, sufficient to engage the obligations of prevention under Article 1. Even if the court were not satisfied at this stage that genocide has been committed, Israel remains bound by an independent obligation to prevent genocide. That obligation arises when a state knows, or should have known, of a serious risk that genocide may occur. Here, repeated warnings from United Nations bodies and humanitarian organizations have made that risk unmistakably clear. And yet, the conduct giving rise to those warnings has continued. Mr. President, members of the court, the rights asserted by South Africa on behalf of Palestinians in Gaza under the Genocide Convention are plausible. The risk of irreparable prejudice is immediate and ongoing. Death, starvation, and destruction continue as these proceedings unfold. There is urgency, and there is no alternative mechanism capable of preventing irreversible harm. South Africa, therefore, respectfully requests that the court indicate provisional measures requiring Israel to, first, cease acts that may fall within Article 2 of the Convention. Second, ensure the provision of humanitarian assistance essential to survival. Third, prevent and punish direct and public incitement to genocide. And fourth, take all measures within its power to prevent further harm to the Palestinian population in Gaza. Mr. President, South Africa does not ask the court to decide the merits today. It asks only that the court exercise its well-established authority to preserve rights and prevent irreparable harm pending its final judgment. The Genocide Convention was adopted precisely for moments such as this, when delay risks rendering justice meaningless. Thank you, Mr. President, and thank you, members of the court.